Hey, can you hear
Hi,
me?
how are you doing?
Good. Okay, let me check my volume. Make sure I've got my volume up.
Okay. Well, I tell you what, today, why don't I just sort of give us a bit of a bumper as to why we are here? Beth Godwin-Jones, you are here to talk to us today about various eviction diversion pilot programs that are going to go into effect on July 1st, 2020.
Correct.
So, starting off here, which courts will be required to participate in this mandatory program beginning on July 1st?
Right, that's a great question. The four courts that are specifically required to use this program are the cities of Danville, Hampton, Petersburg, and Richmond. So this is the pilot program version. It's supposed to run for 3 years, and then it'll be reevaluated at some point along the way to see if it should be given broader application to all courts.
Absolutely. And worth mentioning that this program was established under legislation from the 2019 General Assembly session. Uh,
Correct.
Delegate Chris Collins patroned House Bill 2655, which established this. And the report that will eventually be due will be due to the various chairmen of the concerned committees in the General Assembly.
Right. So this concept was introduced by the Poverty Law Center and some other advocates for tenants in this state. And the code itself states the four goals that the program is supposed to fulfill. Number one, the goal is to reduce evictions of low-income people for failure to pay small amounts of money. And this is especially geared towards people who have had a one-time financial crisis that prevents them from addressing that crisis and also continuing to pay their rent as provided in the lease. So that's the big picture, the goal. And I think it's important to keep that in mind because it really plays out in the criteria for participation that we'll talk about at some point. The second big goal was to reduce displacement of families from homes that would cause harmful effects, especially on children who had to leave one school and maybe go to a different school mid-year. Also, the third goal was to encourage the understanding of the eviction-related processes and for facilitating a landlord-tenant parties to enter into a reasonable payment plan that would work to the benefit of both of them. And then the last thing is to encourage tenants to make payments according to the lease. So this is a little bit of an education element that was also one of the goals to help people, I think, improve their financial management skills. Right, those are also spelled out very specifically, and they're designed to weed out your chronic late payers and to hone in on those tenants who really have had a one-time crisis. They've been good tenants up to now, but they had this one thing, car broke down or a serious illness, so they weren't able to work, things like that that were beyond their control, but impacted their ability to pay rent. And there's 7 requirements that are spelled out in the code. The first is that the tenant has to ask on the first return date to be referred to the program. And on that first return date, the tenant also has to pay either to the landlord directly or into court at least 25% of the amount that's due on the unlawful detainer, as amended to include any additional amounts that have become due as of that date. And so right there, you see there's kind of a trap because you have to know that amount in advance, and you have to have, payments are supposed to be made by certified check. And so you have to have been able to go and get a certified check for 25% of the amount to have it available on the first return date. So there's a little bit of a logistical problem that might require some coordination with the landlord in advance. On that first return date, the tenant has to provide sworn testimony that he or she has sufficient funds to be able to make the payments going forward. In other words, it was a one-time crisis, and they're now back on track to pay the current rent and then to make this additional payment towards the arrears. And they also have to provide sworn testimony explaining the reasons that have been unable to make the payments as the lease requires. So that they have to basically say, this is why I didn't do it, so that to show that they had this one-time crisis. Then there's something that is going to impact the landlord or landlords. The tenant can't have been late within the last 12 months by either more than twice in the past 6 months or more than 3 times in the last 12 months. And they haven't had a right of redemption within the last 6 months. And you recall that right of redemption is good for 12 months, but you can't have exercised that right of redemption within the past 6 months. And they also haven't participated in another eviction diversion program in the past 12 months. So if you moved from one jurisdiction to another that was covered, you can only use it once in either place in 12 months. And if you think about those requirements about the tenant, the delinquency, that shows that the landlord is going to have to be in these jurisdictions, is going to have to be prepared with that information on the court return date, because that's when the court is supposed to make that initial decision that the tenant either qualifies or not. So you or your agent or your attorney would need to have information about any cases that you're going forward with, a ledger, copies of prior notices, something that would show that they have or they haven't met those criteria. So you don't have to continue the case. If they don't qualify, you want to be able to eliminate that as an option right away up front. But then you're just dealing with the people that really meet this criteria.
Gotcha. And so thinking about, the city of Richmond has had a program up and running since late last year. And you, as a practicing attorney in the Richmond court, I wondered if you could sort of go into your experience with the voluntary version of the program that Richmond has kind of been running for these past few months.
Yeah, it's a really interesting question. I'm not sure how much that will transfer to other jurisdictions, because Richmond was fortunate to have a grant provided by the city of Richmond. It was funded by the city. I can't remember if it was $300,000 or $400,000, but it was a good sized grant. And their goal was to be able to assist some modest amount, like a couple hundred people over the course of 12 months. And from what I've been able to see, they've not really had much success matching up applicants to screen them out to make sure that they meet these criteria. And even they've expanded the criteria a little bit because it was still voluntary. So they were able to assist people who might not have met these really stringent requirements. Maybe they had been late another time or two more than they would have been allowed for it to be mandatory. They had the flexibility to do that since this was a strictly voluntary program. My impression is that they've struggled to find enough people to use their grant funds over the year, although I haven't received any information on that directly. I just know that we really were thinking we would be swamped by people because the grant pays up to 50% of that arrears. So anyone who would qualify that program surely would try to do so. But my impression is that they even have extra money, and they are sometimes able to fund people in excess of that 50% amount because they do have sufficient funds to be able to go beyond that. As far as the on the ground experience with Richmond, other than being kind of surprised that there wasn't more people asking to be continued, it's been a little bumpy on my end. It's been my reaction to it. The first thing is that almost never are people prepared on the first return date. Now, the city of Richmond has printed, or home, it could be home because the grant by the city is administered by home.
And by home, you mean
Housing opportunities made equal. That's right, thanks. And those documents are attached, one's colored green to let people know about the program. The other is bright blue that has educational opportunities. So home has really taken to heart this goal of advancing education of tenants. And they have a course, two-part course in financial planning that's required. And if you want to get funds from that grant, you have to participate in 2 sessions that help you learn about budgeting and financial skills. Now, Richmond has a bunch of volunteers who are helping work this program. They have an 800 number or toll-free number, so you can call in as soon as you're served with the paperwork. You know right away about this program, at least theoretically, that's the goal, and you have a contact number to reach out and to try to get this process started right away so that you can have everything ready by the first return date. But still, our experience is that people don't take advantage of that. So they have had volunteers in the courtroom every morning when they have court, and they are talking to people who are applying then and there in the court, and in the waiting room right outside the court. They're trying to screen people and find out if they would qualify, if they're good, applicants. And then they ask if landlords would be willing to work with them and to continue the case for 2 weeks for them to process the paperwork. So that's almost always been my experience, is it requires the first continuance just to find out if the tenants are going to qualify or not. And then, of course, since it's voluntary, I would always try to reach the client before the 10 o'clock court date to find out if they were willing to work with the tenant or not. Since, again, I didn't have that information about their background beforehand, I wasn't able to say, yes, they're a good candidate, or no, they're not. I had to try to find out from the client first, or generally I would continue the case, because one thing to keep in mind is that these 4 courts, are going to be monitored very closely to see if the rate of eviction cases, actual evictions granted, is going to go down or not. And so they're under a lot of pressure from the Supreme Court, who's monitoring their performance. And they really want to make that program work. They really want to provide that opportunity for people. Most people are aware that the Supreme Court has halted hearing unlawful detainer cases until the end of June, the 28th of June, for the purposes of the governor coming up with some funding for housing opportunities for people. And I'm wondering, in thinking about it, if that wasn't partly to provide a pool of funds like the city has had for these other 3 jurisdictions, so that would be a good way for them to help grease the wheels of that program and help make it work a little bit. So we'll have to pay attention to that and see if that is one place that they put some of the funds from that program. So the first problem that I've noticed with the implementation in Richmond is that it does generally require additional delays of time. And the second thing is that it's been a bit clunky, and if a case fails, it fails really dramatically. I had one case where the tenant, and most of our clients honestly want to work with people. They're open to that, and they're glad to have the tenants who are behind get some funding to help them be able to catch up. The one tenant had not disclosed all of his income to the home team that was processing the paperwork. But they didn't discover that until after the case had been continued out. The paperwork had been signed, and then the case had been continued out. And then COVID hit, so now I've been unable to even to get that case before the court. So, so that's, if it messes up, it really can be a horrible problem. The tenant also hadn't disclosed that additional income that put him over the limit to qualify for the home grant to the landlord, and really that tenant is now over income for this affordable housing community. So maybe it was good that they discovered that, but it's been ongoing since February, and we still don't, still have no idea when we'll be able to hear that case. The other problem that I've encountered is with that tenant. I tried to follow the procedures. So the system anticipates making payments of 4 payments of 25% of those arrears, one payment each month, 1 at the initial court date and then 3 following that. And the case was then continued out till date after the last due date of the last payment. And if the tenant fails to fulfill the payment schedule plan, theoretically, the landlord can send a notice to the court that the tenant has failed to do so, and then get into court, and without even having a hearing, you're supposed to be able to get an order of possession. And then it would be, the tenant has a right to submit a letter in 10 days saying, oh, I did make the payment. The landlord just didn't credit it properly to my account. I was not able to have that hearing. The court just would not do so ex parte like that. So the whole framework, and this was negotiated by VAMA and other landlord groups, the whole framework was to have it be easy. So it gave the landlord the benefit of a quick out if the tenant defaulted. But now that's going to add another, at least in the city of Richmond, you're going to have to add another fee for the lawyer, or another trip by the agent if you're doing that yourself. And again, that they're very particular about what fees they'll allow you to charge to the tenant in the city. So that may be something that costs you out of pocket. So that's been sort of a negative fact. The home is really trying hard to screen people because they don't want to have those bad experiences. So they have been working really hard to verify income and to provide the training, the classes that will help people succeed. So, another thing that I thought might be an interesting question would be to consider if you're now in this mandated program and the tenant falls outside of those requirements by a little bit, what would you do? And so that's a problem. That's something that individual properties would want to come up with a policy on that. Are you going to give the tenant a little wiggle room, especially if there's some funding available? Are you going to basically let it come under the program? And then the question is, would it come under the program if they don't really qualify? I think you'd have to disclose that to the judge. They technically don't qualify, but I'm willing to work with them under this program anyway, so that you come under the benefit of having that theoretically expedited process where you can get the order of possession entered quickly. And if not, if you want to across the board say you're going to follow these guidelines strictly, I think you still do have the ability. I think that's what landlords have been doing all along. Most of the people that I know of are willing to work with payments with their tenants. They want the tenants to succeed, just like the General Assembly did. It just perhaps stretches the payment schedule out over a little more time. So perhaps you'd want to voluntarily do that for the tenant on your own to give them a little bit of extra time rather than say, no, I'm going to go full blast ahead file the writ as soon as I can, and you have to pay before the sheriff arrives. Maybe it's an opportunity for properties to step back and see. We've had a lot of experience with the working out payment plans where we're kind of forced to. So maybe that's a little bit of a mindset that you really can try to work with people if they're able to show you that they'll be able to do it and that you want to keep them in the property. So that's something that properties should be prepared to think about, I think, before July 1st. How are you going to react if someone almost but not quite qualifies for this program? I think it's a good opportunity for landlords to demonstrate that they really do care about their tenants and they really are committed to working with them. It stretches it a little bit because most landlords don't want to wait that long. But I do think it's important to try to work with people when you can under these programs because, again, there's going to be a lot of scrutiny of them. And the judges and the clerk's offices are going to be evaluated. And I think there's going to be some pushback if no landlords, if you try to throw up obstacles or if you don't go in it wholeheartedly. This is a good opportunity for us to show that we really are committed to keeping people in housing. And these are difficult jurisdictions with a lot of poverty. I really do hope that the governor will come up with some kind of funding mechanism as part of his planning. It's interesting that judicial emergency ends June 28th, which is just around the corner from July 1st. So hopefully that halt on the eviction cases being, you can't even file them in some courts, but certainly not being heard at all, and no writs being processed through the 28th. Hopefully that will give them a time to come up with the funding sources that would really make this a powerful opportunity. And I think that helps reassure landlords too that they actually could get paid. And having some access to these educational programs, again, it's a good opportunity for everybody to take a refresher course in planning and not knowing when a pandemic is going to strike and planning ahead for emergency circumstances. And I think it is important that the courts perceive you as a landlord when you appear in front of those four courts, that they perceive that you're trying and that you're buying into the program. I think that's going to buy you a lot of goodwill with the court if you are willing and eager to do that, to give your tenants this opportunity. It's an image boost that we can use right about now.
You are absolutely right, Beth Godwin-Jones, Godwin-Jones and Price. And speaking again about the eviction diversion pilot programs that will be coming up in the jurisdictions of Danville, Hampton, Petersburg, and continuing in the city of Richmond. Beth, again, thank you so very much for joining me. I'd love to give you the opportunity, if you have any final comments or if you'd like to just dance your way off. Either way, just cannot tell you how grateful I am, and I know that the members will be for getting your sage advice on this.
Yeah, well, thanks for the opportunity. I always like to share my experience with other landlords so that perhaps they can benefit from that. I really have to admit that I was totally skeptical when I first heard about this bill. And I thought, oh no, what are they doing to us now? When landlords don't have enough to deal with without having this thrust upon them. And though it has kind of been a clunky rollout in the city of Richmond, still, it is such a great opportunity for tenants. And I know that the legislators that I've spoken to on Lobby Day have expressed this really concern that they hear from their constituents of having a one-time crisis. They just need a little bit more time. If they just have to take care of that crisis, and then they can get back on track. So I've come to think of it. It's a lot more work. but if it gives opportunities for people to stay in their housing, especially where children are involved, what a great thing for landlords to be able to do. So I've tried to, to embrace it and to carry that messaging forward. I think it really is a good opportunity for us.
And I don't think that there's a better way to sum it up than that. Beth, one more time, cannot tell you how grateful we are. Everybody, Beth Godwin-Jones, legislative leader here at VAMA and partner at Godwin-Jones and Price. Beth, thanks so much, and have a good one out there today.
You too. Thanks, Tommy.